Tell me about Title VI of the Civil Rights Act of 1964.
Title VI, I believe, Senator, is the provision of the Civil Rights Act of 1964, which prohibits the discrimination based on religious preferences, I believe. Oh, I'm sorry. May I strike that? I'm sorry, Senator. I was thinking of Title VII. Apologies. As you're well aware, I'm sure from my record, Senator, in my 18 years as a federal litigator, as well as my 4.5 years on the state court bench, I didn't have the opportunity to litigate issues related to Title VI of the Civil Rights Act. So apologies for the misstatement. And were I to be so fortunate to be confirmed, Senator, I would make sure with no uncertainty that I would be fully fluent in that issue were it to be presented to me on the bench.
Okay. Judge, is it Bisco?
It's Briscoe.
Briscoe,
Senator.
I apologize.
No problem.
Tell me about Title VI of the Civil Rights Act of 1964.
Senator, in my 17 years as a member of the bar and 5 years on the bench, I have not had the occasion to address Title VI in my career. However, if I am so fortunate to be confirmed as an Article III judge, I would certainly research and study to be prepared to address that issue, sir.
Judge Lund?
Thank you, Senator Kennedy. I cannot add anything that my panelists have not otherwise add. I can also assure you, though, in the 15 years that I've had the privilege to serve as a judge, that particular provision has not been put before me, but if it were to, I would faithfully review it and appropriately apply all Supreme Court, United States, and Seventh Circuit Court precedent that's put before me.
Well, Title VI is kind of timely, isn't it? I mean, I'm sure you all read the newspapers, right? Where does the standing requirement come from?
Senator Kennedy, the standing requirement stems from the cases and controversies provision of Article III.
Okay, thank you for that. Judge Briscoe, I got it right this time. Tell me about the law of the case doctrine.
The law of the case doctrine is when a case has been adjudicated, then there cannot be any other collateral claims stemming from the issues that were already litigated.
Okay, thank you for that. Tell me about, Judge Lund, tell me about federal preemption.
Thank you, Senator, for that question. In just using the words in and of themselves, I would assume that that the phrase speaks for itself, that federal law would preempt anything else that would come before it. But again, if I were posed with that particular legal phrase, I would do all that I could to faithfully review what specifically it is about and faithfully apply that definition to whatever the situation was that was posed in front of me.
Well, where does federal preemption come from?
Well, federal preemption comes from the Supremacy Clause, that federal laws and the Constitution are supreme and state courts are required to uphold them.
And how do you know if there's federal preemption?
Again, I would look towards Article 6 of the Constitution, which again is the provision in which
You won't find it there. How do you know when federal preemption happens? You're going to see it a lot as a federal judge.
Look, here's the bottom line. These nominees have impressive resumes, but this hearing exposed some serious gaps in their knowledge of fundamental legal principles. It raises important questions about the qualification process for federal judges who will be making decisions that affect all Americans. If you found this breakdown helpful, make sure to smash that subscribe button and hit the notification bell. Drop your thoughts in the comments below. Do you think these nominees are qualified for lifetime appointments? I'd love to hear your take. Stay informed, stay engaged, and I'll see you in the next video.